morning. My name is Jenn Truong. As we head into the last quarter of 2023, I wanted to bring your attention to 5 developments we're currently watching for potential impact on your 2024 workers' compensation claims. So let's get started. Impact number 1, independent medical examination recording. Senate House Bill 1068 passed, which amended RCW 5136070, which allows IME recordings as of July 23, 2023. Now, claimants may record their own independent medical examinations using audio, video, or both. Claimants must still provide notice 7 calendar days before the IME date, and employers are entitled to a copy of the recording within 14 days as long as it is requested after issuance of the IME report. What is the significance? Well, employers rely on independent medical examination opinions to support a decision regarding whether to protest allowance, reopening, new medical conditions, or treatment related to the industrial injury or occupational disease, as well as to determine whether or not to dispute work restrictions and or impairment. Since July of 2023, we've noticed an uptick in canceled IME due to physician inability to co-record exams. We've seen that claimants are withholding their consents to have dual recordings, i.e. allowing the physician or the IME panel themselves to also record the exam. This further expands upon claimants' rights with regards to independent medical examinations, since, as you may be aware, last year of 2022 in April, there were also a number of statutory rights given to claimants as it pertains to IMEs, one of which was a 28-day notice. And so, as you can imagine, as we delay and the necessity for exams to be rescheduled increase, this delays our ability to close claims, and there are increased time loss costs. So what can we do? If a claimant is represented, request an IME physician from an IME company that actually allows for recording. There are some physicians that are okay with even a unilateral recording. Request a copy of the claimant's recording as soon as the IME report is issued. This will give you additional time to review and determine if there are any objections to any concerns that the claimant may have with the IME examination and resulting opinions. Support legislative efforts to provide an express right for employers to co-record. Right now, employers do not have that ability. As well, provide feedback to the Department of Labor and Industries if your IME is canceled, delayed, or rescheduled, so that they have the feedback to know that the legislation passed isn't quite working and maybe they need to issue different guidelines. Impact number 2, ergonomics regulation. So what is it? Senate Bill 5217 was signed by our governor, which repealed the prohibition on regulating working practices related to work-related musculoskeletal disorders, or WMSDs for short. The Department of Labor and Industries determined WMSDs are the leading type of occupational injury in Washington state. This allows the department now to adopt ergonomics regulations to prevent WMSDs for an industry or a risk class. So what is the significance? Well, when we look at these common disorders identified by the department, we notice that they may not be distinctive to work activities. Things such as back strains, rotator cuff syndrome, sciatica, or even carpal tunnel syndrome may be conditions that somebody may have as a consequence of just aging and natural progression. So the concern for employers is, one, of course, there's a cost for compliance. If the department sets guidelines and statutory requirements for safety and health regarding ergonomics, there is a cost for employers to develop programs and meet those standards, and as well as the increased claims that could come about from these new identified regulations. So what can we do? If you have not already done so, incorporate or develop an ergonomic program as part of your accident prevention program. You can also request the Department of Labor and Industries come in for ergonomic consultation. I will note that if you have a safety and health citation that is pending, as in it's not final and binding and resolved, the department will not come in for a consultation. You'll have to wait until that is resolved. And of course, continue to monitor development of these department regulations to ensure compliance. Impact number 3, work from home. So this is nothing new, but a continuation of our concerns since the pandemic. Many employees are now working a permanent hybrid schedule. Employers have concerns regarding whether an injury occurring outside of the job site or office is actually work-related. What is the significance? Well, we have a very vague standard. Workers injured in the course of employment or acting in the employer's direction or in furtherance of the employer's business are entitled to workers' compensation. But what if you're working from home, you're getting up to grab a cup of coffee, and you're tripping over your dog, resulting in an injury? Is that covered under workers' compensation? We have some doctrines that can guide us in regards to whether something is in the course of employment. This list isn't exhaustive, but I have listed it here as some examples. So what can we do? Whether a worker is in the course of employment is fact specific. So focus nearly on the activity that caused the injury. You may want to request a specific interview with that worker, have a third party interview them to gather exactly what happened and in what timeline. Identify the job site for the work from home employee in relation to the injury, and consider whether that activity resulting in injury can be considered a covered personal comfort, such as one of the doctrines that we mentioned earlier, such as a minor deviation. So if somebody is working from their home at their desk, they merely get up to grab a cup of coffee and injure themselves. We could consider that a minor deviation or a break that is reasonable that would result in that injury being compensable under workers' compensation. So if we have not already, establish a telecommuting policy. Define the job site, hours, duties, and breaks so it's as clear as possible, and guidelines and expectations for a safe working environment. And that is something that can be included in your accident prevention program for the safety and health side. Impact number 4, increased mental health diagnoses. So due to maybe the pandemic transition or general social awareness of mental health conditions, we have seen an uptick in mental health diagnoses as part of workers' compensation or occupational disease claims. Under WAC 296-21-270, we know that treatment is covered for mental health conditions caused or aggravated by an industrial injury or occupational disease. And we also must remember that the department may cover even pre-existing or unrelated mental health conditions that are delaying or preventing recovery of an industrial injury or occupational disease. So what is the significance of this? Well, it could be a barrier to claim closure. So we need medical fixity and a finding that the claimant can return to some sort of work in order for a claim to close. You can imagine that if a claimant subjectively believes that they really need continued treatment or they cannot return to the job of injury, it will be a barrier because we do not have the ability to take an X-ray or an MRI as we would a physical condition. We rely on the subjective statements of the claimant as to how they are doing when we're measuring mental health diagnoses. And so this creates increased claim costs. Again, there might be additional time loss compensation. There could be an increase in PPD as there is a new condition and diagnosis under the mental health diagnoses. There could be an increase in the experience and modification rate, which impacts your industrial insurance premiums every year. And of course, if you are part of of a third-party administrative group that could impact your refunds. So what can we do? First, assess coverage for compensability early on. Request those pre-listing chart notes, request the independent medical examination to really evaluate whether or not this is something that we can challenge. Another key factor is monitor for treatment and determine if there's meaningful improvement in regards to how the mental health condition is progressing, to see if there is no further impact and that it can be terminated. Another huge factor is return to work transitions. A lot of times when our workers are diagnosed with anxiety or depression, getting back to work is often a huge hurdle. And so providing options for schedule modifications, rest area, or clear timeline for communication could address those barriers. And again, a mental health wellness program is also a consideration. Some employers have invested in providing their employees access to meditation apps or just generally providing wellness programs that could assist. Impact 5, Department proposed rate increase. The Department of Labor and Industries is proposing a 4.9% increase in the average hourly rate employers or workers will pay for workers' compensation insurance in 2024. This fund is used for disability benefits and medical coverage for work-related injuries and illness. The department is justifying this potential increase, due to the economic uncertainty and also, again, the lingering impacts of the pandemic. As workers' wages also rise, so does the replacement cost for time loss. So what is the significance? This has resulted in renewed interest for establishing a competitive private insurance system for benefits in lieu of the monopolistic state and system that we have in Washington. There is a concern because this proposed increase will be across all industry sectors, not just one. And employers are also concerned for the general increase in cost of doing business in Washington state. And this is because the last 2 years there were increases in workers' compensation insurance premiums, as well as unemployment insurance and under the paid family and medical leave. So what can we do? There are public hearings scheduled in October. I've listed 3 dates there that you can participate in. There is also an option to have a safety and health program to, of course, decrease work-related injuries altogether. And of course, take action on your workers' compensation claims. Protest allowance if warranted, protest treatment if you think that the treatment is not improving the worker's condition anymore, and find alternatives for return to work. It has been a pleasure speaking to all of you today. If you have any question in regard to your workers' compensation claim, safety and health citations, or industrial insurance premium audits, please feel free to reach out directly.